Orders of the day.
Private members' business. Resuming debate on Bill C-225, Protection of Pregnant Women and Their Preborn Children Act, Cassie and Molly's Law, in the name of Mrs. Wagantall.
Resuming debate, the honourable member for Sherwood Park, Fort Saskatchewan, with about 5 minutes. It seems to be the order of the day today.
Yes. Thank you, Mr. Speaker. As tempted as I am to respond to my colleague on the issue of trade, that wouldn't do justice to the important subject in front of us. So I want to, again, congratulate my colleague for bringing forward this important piece of legislation, what we're calling Cassie and Molly's Law, Bill C-225. And for those just joining the debate or watching, it's very important, I think, to underline what this bill does and what this bill doesn't do. This bill would create a circumstance under which if a pregnant woman is attacked, is killed, or is assaulted, and her unborn child is harmed or killed in the process of that assault, then a separate offense would now exist under the criminal law, which would punish the person who committed the offense for the attack on the unborn child as well as the mother. And really, punishment isn't the core of it. It is really, the core of it is a recognition of the impact that this has on not just one, but on multiple people. That's what it does. That's what this bill does. What this bill does, it's very important to underline, is it only applies that offense in the case where another offense already exists. There is no possible way under this legislation, and it's very well written and clearly put, there is no possible way in which a person could be charged for an offense against an unborn, preborn child if there was not also an offense against the mother. And I know that any time in this place or elsewhere we have this discussion that involves preborn, unborn children, there is a whole other debate that stirs in some people's minds. But because this only applies in the case where there is an offense against the mother, there is no possible way in which this bill could be twisted or honestly, there's no way in which it could be reasonably inferred to in any way inform a kind of legal change on an issue like abortion. It just is very clear there in terms of the way this bill operates. And I don't think if we were just isolating the question of the bill as it actually exists, I don't think anyone here would disagree with the principle that when there is an offense against a mother and an unborn child, that there is an impact, that there are two beings involved. But the suggestion that we can't pass this bill by some members because it somehow linguistically indirectly seems to invoke another controversy, I find that response to it unfortunate. Because obviously we know that the question, for instance, of abortion is a challenging and divisive one. But can members who disagree on that question not come together on something that I think we should all agree on, which is combating violence against women, and which is the impact that also has on another life? And I know some people object to the terminology. They don't like the term unborn child or preborn child. They'd rather use the word fetus or something else. Well, my understanding is that fetus is just a Latin word for the same thing. So I try and avoid Latin ceteris paribus, but it really doesn't matter what terminology you use. I think the point here is that we have a piece of legislation which is just eminently sensible, which responds to a reality that if somebody loses a child because they're attacked, that they feel that loss in a particular way. And to suggest that they don't, to suggest that is, for the person who is attacked, simply akin to another kind of assault, or to suggest that there isn't an added impact or added element calling out for some kind of justice there, I think it really ignores the lived experience and the testimony of people who have brought forward this issue and who have said this is a priority for us. The bill is named after real people who have real experiences with this, and that have spoken to my colleague and have spoken to other members and have asked that we respond to it in this way, and have asked that hopefully we come together as a House across party and ideological lines. So I'd encourage my colleagues, if they're hearing different things about this bill from different places, to take the time to have a look at the legislation and decide for yourself. Thank you.
Resuming debate, the Honourable Parliamentary Secretary to the Government House Leader.
Thank you very much, Mr. Speaker. And I rise today to respond to, no doubt, what is an important private member's bill. And as other private members' bills come along, Mr. Speaker, I do acknowledge the efforts that members often put into their legislation, their proposed legislation, for a wide variety of reasons. Having said that, I have had the opportunity to go over this particular member's bill and have some serious concerns. Often I stand in this place and I will talk about the importance of the Charter of Rights. I've argued in the past, and I personally believe in Canada's Charter of Rights, and I would suggest to you that the Liberal Party in itself is a party of the Charter of Rights and freedoms. And when I'm going through what is being proposed, and I had the opportunity to listen to the member, I can't help but reflect on that particular issue. It's important that we recognize right from the beginning that the government does condemn all forms of violence against women, including against pregnant women, obviously. We recognize that the criminal law must strongly condemn and hold fully accountable those who perpetrate violence against others, particularly against those of more vulnerable to violence. Mr. Speaker, when I think of the current legislation that we have, I think it's important for us to emphasize a couple aspects that I think are very germane to this particular debate. If you take a look at subsection, for example, 223(2) and subsection 238 of the Criminal Code, you will find, Mr. Speaker, that it carries a maximum penalty of life imprisonment, which prohibit causing of death of a child who has not become a human being in an act of birth under certain circumstances. Another aspect, Mr. Speaker, is to recognize that the Criminal Code contains comprehensive assault and homicide offences which apply to violent acts against pregnant women. Mr. Speaker, I think that it's really important to take a look at case law. I've had the opportunity serving in the Manitoba legislature for many years. One of the privileges I had was at the time serving as the justice critic. And looking at case law and what is actually being practiced through our courts is something in which is really important for all of us to take into consideration. And what you will find is that case law shows that abusing a pregnant woman in committing an offense is considered an aggravating factor for sentencing proposed and punished severely. Mr. Speaker, I think that's a very important aspect that we need to also take into consideration. As I've indicated, criminal law does take violence against women, including pregnant women, very seriously currently. The government believes that gender-based violence has no place in our society, and we are committed to developing and implementing a comprehensive federal strategy against gender-based violence. Canada's approach includes prevention, support for victims, and the criminal justice responses. Mr. Speaker, I am not one to shy away from what I believe are very important issues, and this chamber deals with a wide variety of issues that affect the lives of the constituents in which we represent. And, I represent a riding with Winnipeg North in which if I were to knock on doors, there's no doubt different issues that different people will bring up. But one of the issues that I have found that people, no matter what their background is, that they really want to talk about is the issue of crime and safety as a whole. It's an area of discussion that I genuinely appreciate and want to explore, constantly looking for ways in which we can improve the communities that we live. I have articulated in the past, whether it's at the door or inside this chamber or inside the Manitoba legislature, that individuals have a right to feel safe in the environments in which they live, the neighborhoods and the communities. And in some areas of Canada, in particular, for me, my city, there's areas of concern. I wanted to highlight a little bit of that, given what I've already said about the private members bill, because I do think that it is important for us, when we have the opportunity, to be able to incorporate into our discussions or into the dialogue what we believe are important issues for our constituents. And that's why when I look at Bill C-225, I somewhat understand why the member is bringing it forward. I would tend to disagree with the member and ultimately believe that there is laws that are currently in place that have clearly been demonstrated through our court system that have already taken it into consideration, some of the sensitivities that the member is attempting to bring forward within this legislation. And then I started it off by talking about the importance of the Charter, Mr. Speaker, and that is something in which I believe also needs to be highlighted. So in having this discussion at the doors with my constituents, I do believe that what I am reflecting in the House today is an honest reflection of what I believe my constituents would want me to be saying. In addition to that, Mr. Speaker, I would ultimately argue that there are other aspects of the criminal law that could be looked at or could be considered. We have had a government in the past that has tended to take an approach of getting tough on issues, getting tough on the issue of crime. And sometimes I think that we need to recognize that what our constituents really want us to put more emphasis on is starting to get tough on some of those causes of crime. And this is something that I think we lose sight of at times. So, the member here has brought forward a piece of legislation which caters to a specific issue which raises a number of other concerns that members actually might have. But let me suggest to you, Mr. Speaker, that the best thing that we can do is look at ways in which we can prevent the type of abuse that is taking place against women, let alone pregnant women, Mr. Speaker. We recognize that it does take place. And I would suggest to you that one of the best ways in which we can prevent violence going into the future is to ensure that we have the types of programs that will actually have and make a difference. And that means, for example, I would suggest to you that we have to start working more with our different stakeholders, in particular our province, municipalities, and let me raise specifically the importance of our schools through education and the role that school divisions play in establishing the curricula, for example. If you want to really have an impact on combating domestic violence, as an example, we need to take into consideration the role that our teachers could be playing, that our social workers, whether they work for our municipalities or our provinces. And that's why, when we have legislation of this nature, it does afford us to kind of just expand the debate to really encourage, in my case, the government of the day, which we happen to be a part of, but all members, to explore the ideas that will actually make a difference in preventing some of the abuse that we see taking place in our communities. And I would suggest, Mr. Speaker, that if we put a higher priority on that issue in itself, that we will better serve the constituents that we represent. Because at the end of the day, what this should all be about is making our communities a safer and better place to live. Now, don't misunderstand what I am saying, Mr. Speaker. I truly believe that there should be a consequence for a crime that is committed. I sat as a honorary probation officer, chair of a youth justice committee for many, many years, and appreciate the importance to a consequence to a crime. So specifically with respect to this particular bill that we're debating today, I would suggest to you, Mr. Speaker, that there have been aspects that have been overlooked. In particular, issues such as our current case law and how it has been taken into consideration. In particular, other aspects of our criminal code that does take it into consideration that hopefully will provide some assurances to the members sponsoring the bill. Thank you, Mr. Speaker, for sharing a few thoughts.
Resuming debate, the honourable member for Lethbridge.
Thank you, Mr. Speaker. Mr. Speaker, I stand before you today in order to shed light on a very important topic that is affecting individuals across Canada. The issue in which I speak of regards the Criminal Code of Canada and a crucial component that is in fact missing from this piece of legislation. In current law, if an offence against a pregnant woman is committed, one charge can be laid, which is for the offence against the woman, despite the fact that her preborn child may have also been injured or in fact killed in the altercation. The mother's loss of her child is not recognized in our current system. Cassie and Molly's law, the law that is before us today, is a direct response to pleas for justice. The pleas of moms and dads from across our country who have lost a preborn child due to acts of violence committed against the mother. And I stand here today in full support of this piece of legislation, and I recognize that there is a significant gap in the criminal code which fails to protect pregnant women and their preborn children. The private member's bill was introduced by my colleague, Cathay Wagantall, in hopes of creating a reform. I apologize. May I continue? Thank you. In hopes of creating a reform that will better protect Canadian women and their families. This piece of legislation, if it were to be brought into effect, would establish a new offence for violent criminals who knowingly injure or cause death of a preborn child while committing a criminal offence against a pregnant woman. Our current law, which does not recognize harm caused to a preborn or even the death of a preborn, is absolutely unacceptable in the country of Canada. Criminals are let off without any consequence for their violent actions against mothers who have chosen to have their children. Their actions are destructive and intentional, yet without due consequence. At this time, the firmest penalty for assaulting a woman is 14 years. With Bill C-225, 2 charges could be laid. One charge for the criminal offence against the woman, the mother, and the other charge for causing the death of or injury to the child. The criminal would then face a maximum penalty of life in prison and a minimum penalty of 10 years under this new piece of legislation. Mr. Speaker, the Criminal Code of Canada is in fact missing a very critical component to protect pregnant women. Through this new law, a legal device would be put in place that improves the protection of women and recognizes that safety is of utmost importance. Ultimately, it would fill a gap in the criminal code that would be a response to those who are seeking justice for their loss. Mr. Speaker, this bill was put forward as a result of one man's very tragic and very sad story. This man is Jeff Durham. Nearly 2 years ago, he suffered the heartbreaking loss of his partner, Cassie, and their daughter, Molly. Cassie and Jeff were 2 individuals who chose to commit to being parents to Molly and who eagerly anticipated her arrival. On December 11, 2014, when Cassie was 7 months pregnant, a man broke into her apartment and committed the unimaginable. As a result, both lives were taken that night, leaving Jeff without his child. The man responsible was charged on several accounts, including first-degree murder, break and enter, indecent interference with a dead body, arson causing property damage, possession of incendiary material for arson, and arson with disregard for human life. His crimes are absolutely disgraceful, and no person should ever have to hear of their loved one facing this type of reality. Through investigation, police have concluded that Cassie did not die from the fire, but actually from severe blood loss due to trauma. Police have also stated that the crime scene was one of the most disturbing ones that they have ever seen. Cassie was brutally murdered by a man who was well aware that she was pregnant and only weeks away from giving birth to her baby Molly. Jeff has expressed his thankfulness that the perpetrator was convicted of first-degree murder, but he also has voiced his difficulty in finding comfort as he feels the charges do not properly represent Cassie's rights as a woman. You see, Mr. Speaker, Cassie made the choice to carry Molly to term. She made the choice to become a mother, and Jeff made the choice to become a father. But, Mr. Speaker, that night, that choice was robbed from them. Canada is a nation that values human rights and equality, and I am proud to live in this country that holds to these principles. However, our government has failed to acknowledge that the criminal code is missing a crucial component to protect pregnant women, and ultimately has turned a blind eye to this issue. This piece of legislation is important to making our Canadian democracy stronger, and I am urging the government to stand by me and my colleagues, as well as Jeff and his family, and the millions of other Canadians who believe that this amendment is desperately needed. Mr. Speaker, this issue has gained overall support from both men and women from coast to coast to coast. According to a NANOS poll, it is suggested that 69% of Canadians are in fact in support of a law that would make it a separate crime to injure or cause death to a preborn while attacking a pregnant woman. A study into the deaths of pregnant women determined that a pregnant or recently pregnant woman is more likely to be a victim of homicide than a woman who is not. This is a very scary statistic for families across Canada, and Canadians are looking for ways to ensure that they are kept safe. This bill protects women when they are at their most vulnerable, and it protects a woman's choice to bring her child to term safely. Mr. Speaker, this bill is about protecting the most vulnerable among us and taking a stand against violence, particularly violence against women. By passing Cassie and Molly's law, Canada's government would demonstrate that this issue is not taken lightly in our nation. It would serve as a strong statement concerning the value that we place on women and their right to choose. This bill is about protecting families, it's about standing up for the rights of women, and it's about taking a stand against violence. Now, Mr. Speaker, it was suggested earlier that the criminal law already takes violence against women very seriously. But, Mr. Speaker, the problem that C-225 seeks to address is not that the criminal code fails to take violence against women seriously. Rather, it's that the criminal law does not take certain forms of violence perpetrated against her seriously enough. Specifically, Mr. Speaker, I am talking about these crimes that are committed against pregnant women, thus preventing their choice from becoming reality. Mr. Speaker, that is unacceptable in the country of Canada, and it's time for us to take a stand. Because, Mr. Speaker, Canada is a country that continually seeks to uphold the fundamental principle of justice. We value human beings and their lives, and we recognize that it is vital to continue striving to defend the people who live within our borders. Part of this is defending their freedom of choice. It is time for us to take a stand for pregnant women who have chosen to carry the beautiful hope that lies within them, and that is carrying a child to full term. So in closing, Mr. Speaker, the charges that have been laid on the accused are insufficient and an absolute injustice to Jeff, who is left without ever knowing his daughter Molly. Unfortunately, he will never be able to hold or rock her to sleep or tell her that he loves her. What he is left knowing, however, is that Molly had a loving and caring family that was anxiously awaiting her arrival, but unfortunately that day did not come. It is extremely shameful that Molly's life is not accounted for in the charges against the accused. Sadly, Jeff's story is one of many. He speaks on behalf of those who have experienced similar tragedy and injustice. And going forward, we absolutely need this piece of legislation. We can no longer stand idle to the fact that there are no consequences in place when a criminal knowingly injures or causes the death of a preborn while committing a criminal offence against a pregnant woman. This cannot be tolerated any longer. Canadians are looking to us in this place to take leadership with regards to this issue. They are looking to us to amend this gap. They are looking to us to make the tough call to protect freedom of choice and the well-being of humanity. They are looking to us to contend for Canadian families. Canadians seek a safer environment for pregnant women and their preborn who are susceptible to the same kind of harm and violence that Cassie and Molly tragically endured. Mr. Speaker, I'm calling on this House to support this piece of legislation on behalf of nearly 70% of Canadians that agree we need this change. Thank you.
Resuming debate, the honourable member for Carleton Trail, Eagle Creek.
Thank you very much, Mr. Speaker. I am honoured to rise today in this place and speak to Bill C-225, Protection of Pregnant Women and Their Preborn Children Act, Cassie and Molly's Law. To begin, I want to recognize and thank my friend and colleague, the member for Yorkton Melville, for the good work that she has undertaken in introducing this bill and for the passion that she brings to this important debate. As I have shared in this place before, Mr. Speaker, I am the mother of 4 wonderful children, 3 of whom are married. I am also the grandmother of 7 beautiful grandchildren, 3 of whom I haven't met yet. 1 will be arriving next month, and the other 2 just after the new year in January and February. Our entire family is eagerly awaiting their arrival. Nurseries are being prepared, and books of the most popular names are being pored over. As grandparents, my husband and I can hardly wait to love on them, and yes, spoil them, and then return them to their parents. As my entire family prepares to welcome these 3 new members, the reality that this bill seeks to address is very near and dear to my heart. Let's talk about what this bill does. C-225 allows for 2 charges to be laid for causing the death or injury to a preborn child while attacking a pregnant woman. 1 charge is for the offence against the woman, like assault or murder, which currently exists in the criminal code. The other charge is for the new offence, created by this bill, for causing the death of or injury to the preborn child from the commission of the offence against the woman. The bill also gives added protection to pregnant women, even in cases where the preborn child is not harmed or killed, because it codifies pregnancy as an aggravating factor for sentencing purposes. While judges can already treat pregnancy as an aggravating factor in sentencing, codifying it in criminal law requires a judge to always consider this factor in sentencing. Codifying pregnancy in criminal law is another way to more clearly and strongly denounce violence against pregnant women. I cannot even begin to imagine the range of emotions that I would experience if one of my daughters or daughter-in-law or my unborn grandchildren were harmed or killed by someone. If a woman has chosen to have a baby, should she not be entitled to justice if her unborn child is harmed or killed? This bill would provide some justice. How does this bill do this? Mr. Speaker, justice isn't served when a person doesn't face any consequences for intentionally causing the death of or injury to a preborn child while attacking a pregnant woman. Bill C-225 is aimed at third parties who knowingly commit criminal offences against pregnant women. The new offences are not standalone offences. They apply in a narrowly and precisely defined circumstance. Only when a third party is committing or attempting to commit an offence against a pregnant woman knowing she is pregnant. The stiff penalties of a minimum of 10 years and maximum of life imprisonment for intentionally harming or causing the death of the preborn child will act as a strong deterrent for committing violence against pregnant women, since the offender cannot get to the child without going through the woman. In other words, if the child is protected, the woman is protected. Mr. Speaker, for the remainder of my time, I would like to highlight what the bill cannot do, contrary to what some have suggested. This bill does not change the definition of human being or create false personhood. The criminal law can be used to protect entities other than what is covered under the Criminal Code's definition of human being. The bill cannot be used to criminalize doctors or anybody for performing abortions. And finally, the bill cannot be used to criminalize pregnant women for any acts, omission they may cause that may cause harm or death to her own fetus. I want to quote the sponsor of C-225, who was motivated to bring this bill forward after hearing Cassie and Molly Cake's story. And I quote, "The Criminal Code is missing a crucial component to protect Canadian women and their families. The increased penalties under Cassie and Molly's law create a legal mechanism that will enhance the safety of Canadian women and recognizes the safety of their family. This approach is specific and robust. It is a common-sense approach designed to fill a gap in the criminal code that renders women and their preborn children vulnerable." End quote. Mr. Speaker, I would encourage all members in this place to take the time to read the bill and then support it, as it is clear in its aim, which is to protect the preborn in a very narrowly and precisely defined circumstance when the woman has not chosen abortion and a third party causes death or injury to her unborn child against her will. To conclude, Mr. Speaker, choosing to have a child is one of the most important commitments one will ever make. As a grandmother, I would share in the grief of my daughters and their husbands should anything like this ever happen to them. And finally, Mr. Speaker, as a member of Parliament, I have always and will always stand up for the rights of victims in the face of horrific crimes, and this bill does that. Thank you.
Resuming debate, the honourable member for Kitchener-Conestoga.
Thank you, Mr. Speaker. Mr. Speaker, I rise in the House today to speak in support of Bill C-225, and I want to thank my colleague from York and Melville for tabling this bill, and I also want to thank previous speakers who have spoken so eloquently from their heart. Mr. Speaker, over 63,000 pregnant Canadian women are victims of spousal violence between 2004 and 2009. Since 2000, 24 pregnant women have been murdered. This bill is needed to fill a gap in the criminal code that is leaving pregnant women vulnerable. As the law currently stands, women and families who are violated by those who abuse pregnant women have no recourse in law. Only one set of charges can be laid, but 2 lives have directly felt the impact of the crime. This bill creates new offenses for injuring or causing the death of a preborn child while committing a criminal offense against a pregnant woman when the person knows she is pregnant. This would allow for 2 charges to be laid when someone attacks a pregnant woman and as a result kills or harms her preborn child. In current law, only 1 charge can be laid, and that is for the offense against the woman, because injury or death of the child is not recognized. When an individual receives no punishment for knowingly harming or killing a preborn child through an intentional act of violence against the child's mother, justice has not been served. Bill C-225, Protection of Pregnant Women and Their Preborn Children Act, allows 2 charges to be laid under such circumstances and includes an amendment to paragraph 718.2a of the Criminal Code, which requires the courts to consider pregnancy as an aggravating factor when sentencing those convicted of violence against women. Cassie and Molly are remembered together. Their names have become known in households across Canada. And while this acknowledgement and recognition of the heinous crime committed against both Cassie and Molly lends itself to a small measure of justice, justice has not been fully realized. Where 2 lives full of hope and promise were horrifically ended, only 1 murder charge stands. Mr. Speaker, Molly matters. There is no pro-life versus pro-choice debate. The choice has already been made. Molly's arrival was eagerly anticipated by her mother, Cassie, her father, Jeff, and countless other family members and friends. Mr. Speaker, over the past 10 years, as I've served as Member of Parliament, one of the services I and all members of Parliament offer to our constituents in this chamber is to present petitions on their behalf. Over the past months, and in fact years, petitioners from my riding and all across Canada have flooded my office and the offices of my colleagues, pleading to be heard, begging for action on this crucial issue. While, Mr. Speaker, I have heard them loud and clear, we need to fix this gap in legislation and right the wrong that Cassie and Jeff have to endure. It is true that nothing will bring back the lives of Cassie and Molly, but we can take a stand for parents who have made the choice to welcome a baby into their family and have that choice taken away by violence. The large majority of Canadians agree with the intent of Bill C-225. In fact, Mr. Speaker, a NANOS poll commissioned by the creator of this legislation found that 69% support or somewhat support a law that would make it a separate crime to harm or cause death of a preborn child while attacking a pregnant woman, versus 21% who oppose or somewhat oppose such legislation. Mr. Speaker, the Prime Minister himself has on several occasions labeled himself a feminist. Well, if that is true, I look forward to his support of this legislation, as over 70% of women support these protections. This bill directly acts as a deterrent against the abuse of women and their preborn children. This bill would add pregnancy to the list of aggravating factors for sentencing purposes. Although judges can already treat pregnancy as an aggravating factor, codifying it in the criminal law is a way to more clearly and strongly denounce violence against pregnant women. We know from researching case law that it is often unclear to what extent a woman's pregnancy is considered in sentencing. This bill would send a strong message to the courts that pregnancy must now be considered in the sentencing hearing. Mr. Speaker, pregnant women are 4 times more likely than other abused women to report having experienced a very serious violence, including being beaten, choked, threatened with a gun or knife, or sexually assaulted. This legislation, as I said, would act as a strong deterrent against committing violence to pregnant women because of the increased penalties it would carry for intentionally causing the death of a preborn child. Molly's story reminds me of an incident that occurred close to my riding in London, Ontario. Last year, in a Costco parking lot, a woman unintentionally drove into the entrance, directly hitting a family of 4. The family of 4 was torn apart by the immediate death of a 6-year-old and the death of a baby who was born a week after the incident. Complications arising directly from the accident caused the subsequent death of the baby. The results of this case may not have changed as a result of Cassie and Molly's law. However, the very real reaction from the victim's grandfather and other family members show the emotional heartache that they felt. Whether you have met or were waiting in eager expectation to meet the child. As I said, this case was an accident. How much more pain would this family be going through today if the perpetrator had carried out his offense intentionally? To conclude, Mr. Speaker, listening to the debate this evening and following it previously, it is clear that those who oppose this legislation want to make it about opening the abortion debate. This couldn't be more wrong. This is not about reopening the abortion debate. No part of this legislation could do that. This bill cannot be used to criminalize doctors or any physician for providing abortion. Neither does it change the definition of human being or give fetus personhood. This bill protects the preborn child in a very narrowly and precisely defined circumstance when the woman has not chosen to abort and a third party knowingly causes death or harm to the preborn child against the mother's will. As stated earlier, this bill closes a serious gap in the criminal code. When 2 lives full of hope and promise are intentionally and violently ended, it is simply common sense to expect that our laws would send this strong deterrent message, standing against the abuse of women and their preborn children. Mr. Speaker, tonight and previously we have heard in this chamber by our Liberal colleagues, quote, "Gender-based violence has no place in society," end quote. Mr. Speaker, if that really is true, if my Liberal colleagues really believe that, I ask them to stand up against gender-based violence and support Bill C-225. Thank you, Mr. Speaker.
Resuming debate, the honourable member for Langley-Aldergrove.
Thank you, Mr. Speaker. It's an honor to be able to speak to Cassie and Molly's Law 225. Mr. Speaker, Canadians want fairness. Canadians want justice. And I think this is a prime example and an opportunity to provide that justice in Canada. We are in a situation where a piece of legislation called the Unborn Victims of Crime was presented to a previous parliament, and that parliament decided that yes, this is worthy to be debated, and there was a vote to, at second reading, for it to go on to committee. Unfortunately, time ran out and that parliament ended, and that was a former member of Parliament, Ken Epp. So we now have a new law, and it's similar, but it's been refined to clarify that this is not about the issue of abortion. This is about justice. And Mr. Speaker, what I think and I believe strongly is that Canadians would like this to at least be sent to committee, to the Justice Committee. For clarity, in this House, it is a rarity that a member of Parliament would be given a number at the beginning of Parliament, and that number is the order of precedence. And the member that has introduced this bill was given that unique opportunity of a low number. And there's that connect, too, and she had respected the former minister, our member Ken Epp, and remembered that time where that bill had been sent to committee. And now here she finds herself representing her community and given that opportunity with a private member's bill. And that's an honor, it's a privilege, and it was laid on her heart, and she heard the story about Jeff Durham and the tragic loss where his partner was carrying their 7-month-old preborn child. And they were excited, and then for him to lose both his wife, his partner, and his little girl that was yet to be born, who was already named Molly, 7 months old, so just a couple of months and Molly would have been born. And Mr. Speaker, he wants justice. Canadians want justice, and I believe strongly, and I think majority in Parliament here would agree, that Jeff Durham deserves the opportunity to go to the Justice Committee and tell his story and why he believes we need changes in the Criminal Code of Canada. At this point, the Criminal Code does not recognize the loss of Molly. It recognizes the loss of Cassie. And, Mr. Speaker, the government has said that they are opposed to all forms of gender violence, all. And this is their opportunity to vote to allow it to go to committee. And that's what the vote will be happening shortly on the second reading. And this is traditionally a private member's bill is a free vote. And I would hope that the Prime Minister would allow justice, would allow fairness, would allow transparency, and would allow victims of crime in Canada an opportunity to have a voice in this Parliament. And that will only happen if members of a majority government, a Liberal majority government, give the opportunity to Mr. Jeff Durham and others to come to committee and speak. If they vote against 225, it ends, it dies. And justice is not served, fairness is not served. And so, Mr. Speaker, I cannot dream what it would be like to experience the loss that Jeff Durham and family has experienced. But he, I believe, has the moral right to go and stand before committee, the Justice Committee, the Standing Committee. And that's what this structure, this Parliament has been set up exactly for examples like this. And to cut the process short, I think would be a travesty of justice. Mr. Speaker, if after hearing from a victim and the government still considers that 225 should not be supported, that would be their opportunity after this has been sent to committee. But to cut it short before the victim has a chance to speak and present their loss and why they strongly believe that the criminal code needs to be changed and improved is not transparent, is not open, is not inclusive. So this is an opportunity to really, it's a test for this Parliament. Is this Parliament a majority Parliament where the Liberal Party of Canada and the Prime Minister have a majority in this House? This is their opportunity to do the right thing. And, Mr. Speaker, I trust that they will. They've said that they're not going to support this, but I believe that there should have a second thought, an opportunity to reconsider and an opportunity to allow Jeff Durham and others to come to the Standing Committee of Justice. By removing that opportunity, I think would leave a very unfortunate message that only certain people, only certain issues will have an opportunity for justice. Only certain issues will the government listen and consider. Is this an opportunity where we should listen, should allow a victim to have a voice? I believe so. This is a prime example. And so I count on the government. I ask the government, and particularly every member in this House, to allow Jeff Durham and family to have a voice to call for justice, a voice to call for an amendment. Please allow, Mr. Speaker, I ask this House to please allow justice to prevail in this land. Canada is known as a country where you can be treated fair. You can accomplish whatever you want with hard work and commitment. And, Mr. Speaker, this is that opportunity for this House to show its true colors, of justice, fairness, respect for law, respect for justice. And, Mr. Speaker, the world watches things like this. And it also, our children look at things like this. And this is a political House, a partisan House at times. But this is also an opportunity to lay aside partisan issues and to do the right thing. Each of us are here for a short period of time. Each of us will look back at our time here and we will do some soul searching and think, did I do the right thing on that? And maybe at all times we don't do the right thing. But this is an issue of conscience, Mr. Speaker. It's been made very clear that this is not reopening the issue of abortion. It's, should the victim have the right to share their experience, the travesty that they went through? Would that be part of a healing process? I hope so. And hopefully this House will not deny justice to be done. And so I thank you very much, Mr. Speaker.
Resuming debate, the honourable member for Yorkton Melville.
Mr. Speaker, it's an honour to close the second hour of debate on my private member's bill, Cassie and Molly's Law. This bill is in response to the 2014 murder of Cassie Cake in Windsor, Ontario, when Cassie was weeks away from giving birth to their daughter, Molly. In Canada, there's no component in the criminal code to protect pregnant women from violence. This gap is leaving women vulnerable. Cassie and Molly's Law will address this specific issue to protect pregnant women and their future families. Since introducing this legislation in February, I have been inspired by the support of Canadians across this country for Cassie and Molly's Law. Through a flood of letters, phone calls, emails, meetings with everyday Canadians that know both Cassie and Molly deserve justice, as do all the women that have been victims of violence while pregnant. The Canadian Resource Centre for Victims of Crime endorsed Cassie and Molly's Law because it is justice for victims of serious crime. The Native Women's Association of Canada has endorsed Cassie and Molly's Law because this bill is one step closer to justice for at least 18 of the missing and murdered Aboriginal women and girls. Canadians want this legislation. In a nationwide poll by Nanos Research in which 97 respondents identified as pro-choice, nearly 70% of Canadians were supportive of this legislation. Support among women was even higher at 75%. Canadians understand what this bill does, and just as importantly, they understand what this bill does not do. This bill creates new offenses for injuring or causing the death of a pregnant woman's preborn child while committing or attempting to commit a criminal offense against the woman. These offenses are not standalone offenses. The new charges under Cassie and Molly's Law only apply when a person is committing or attempting to commit a criminal offense against a pregnant woman. In addition, charges could only be applied when the offender has the knowledge that the female victim is pregnant. The new offenses are called causing the death of a preborn child while committing an offense or injuring a preborn child while committing an offense. With this law, 2 charges can be laid in crimes involving attacks on pregnant women that result in the harm or death of their preborn children. One in relation to the criminal offense against the woman, and the second charge in relation to one of the new offenses, either causing the death of or the injury to the preborn child. Cassie and Molly's Law would also add pregnancy to the list of aggravating factors for sentencing purposes. Codifying it in criminal law is a way to more clearly and strongly denounce violence against pregnant women. While the government suggests that courts consistently recognize pregnancy as an aggravating factor, I want you to know from deeply researching case law that it is often unclear as to what extent a woman's pregnancy is considered in sentencing. And Mr. Speaker, opponents of Cassie and Molly's Law claim that this bill could be a backdoor to limit a woman's access to abortion services. This is untrue and entirely misleading to Canadians. Simply put, Cassie and Molly's Law only adds new offenses for existing crimes against a pregnant woman that result in injury or termination of her pregnancy. Because this bill only affects existing crimes and abortion is not criminal, Cassie and Molly's Law has no impact on abortion services. The bill does not change the legal definition of a human being or create fetal personhood, as some critics have tried to claim. The constitutional experts at the leading firm, Supreme Advocacy, which this government highly respects, confirms that Cassie and Molly's Law has no impact on abortion laws. In fact, I would challenge the Justice Minister or the minister's representatives in the House of Commons right now, today, to present legal arguments that refute the expertise of these lawyers. Addressing violence against pregnant women is the strict and sole objective of this bill. Mr. Speaker, the government promised a strategy to combat gender-based violence. We're still waiting. Yet right here, right now, we have an opportunity for Liberal government and every member of Parliament to take a step towards reducing gender-based violence in Canada. Mr. Speaker, Member of Parliaments are here to serve Canadians, and Canadians have made their voices heard loud and clear. They support this bill. Proof? An e-petition with 6,100 signatures, paper petitions over 20,000 plus, letters, emails, phone calls, reflecting all ages, men, women, expectant mothers, pro-choice supporters, victims, and those left to mourn. The Nanos Research poll confirming 70% of Canadians cannot be denied. Mr. Speaker, Canadians across this great country support Cassie and Molly's Law, and they expect this House to do the same.
The question is as follows.
Seconded by Mr. Albrecht, moved that Bill C-225, an act to amend the criminal code injuring or causing the death of a person, child, while committing an offence, be now read a second time and referred to Standing Committee on Justice and Human Rights. Is it the pleasure of the House to adopt the motion? Yes. All those in favour, please say yea. Yea. All those opposed, please say nay. Nay. In my opinion, the nays have it. Pursuant to Standing Order 93, the Recorded Division stands deferred until Wednesday, October 19th, 2016, immediately before the time provided for a private member's business.